The Embrace project has petitioned the Constitutional Court looking to challenge the constitutionality of rape and consent definitions. The Embrace project argues that the current definition of consent is problematic and potentially unconstitutional, as it may not fully protect individuals' autonomy and the right to make informed voluntary decisions regarding sexual activity. The founder and director of the Embrace project, Germanos, joins us now to talk further about their legal challenge. Leanne, good evening. Thank you very much for joining us on The Full View. Let's start with just the current key issues raised by your organization regarding the current definitions of consent and rape in the Sexual Offences Act. Just talk to us about these.
Evening, and thank you very much for having us. So the constitutional challenge that my organization is bringing has to do with a number of provisions in the Sexual Offences Act, which all have consent as an element. The challenge that we're bringing is really very specific to one of the elements, which is intent. So if I were to use an example, if we were to take the sexual offence of rape, there are 4 elements that need to be proven by the state before you can get a rape conviction. The 4 being unlawfulness, intention on the accused part, there has to be an absence of consent, and there has to have been an act of sexual penetration. Usually the state shouldn't have a problem achieving at least 3 of those elements, or proving 3 of those elements. If they find that a case is strong enough to go to trial, they should be able to prove those 3 with sufficient ease. The problematic element is the element of intent, and that is actually what we're targeting in our constitutional challenge.
Mm-hmm.
As the law currently... Sorry?
Yes, you can continue, Leanne.
Thanks. As the law currently stands, the intent element requires the application of a subjective test. So what that in effect means is that the courts actually ask the question, what was the accused thinking of subjectively? Was the accused subjectively intending to commit a rape? Mm-hmm. And now that causes quite a major problem for the state to prove, because it's almost impossible to rebut in the instance where an accused person says, well, you know what, there was absolutely no outward sign of opposition to what I was doing. The complainant didn't refuse either verbally or physically by pushing me away. So I had no way of knowing that there was an absence of consent. And that is actually what we're challenging.
Mm-hmm. Do you want an objective testing of this intent?
Absolutely. That's exactly the test that we're going for. What we're asking the court to do is actually, for the moment at least, read into that particular provision and all provisions that concern the element of consent. We are asking that the court reads in a requirement where an accused person should be required to take all reasonable steps to confirm that consent has been given. So in other words, we want the law to move away from encouraging perpetrators and accused persons from not clarifying whether or not consent was given, from relying on the fact that they have not received a no, and rather pushing for a confirmation that consent was given.
Mm-hmm. Now, what is the position of the Minister of Justice on the proposed changes to the Sexual Offences Act? Because one assumes you would have lobbied the minister before even going this route.
Absolutely. Actually, in about 2020, there were 3 GBV-related bills which were up for amendment. And just before those bills were signed into law, and in fact we were actually, as the Embrace Project, quite involved in the legislative process, in the parliamentary legislative process leading up to the amendment of those bills. And in our submissions we pointed out some key issues that we thought existed in the Sexual Offences Act and which were absent from within the Act, which were not taken up by Parliament and were not amended. And then just before the President signed those amendment bills into law in 2022, we sent a letter to the President saying, please don't sign the bills as they are currently. They're actually unconstitutional, and this is why. There's this very particular element or issue with sexual offences that you still need to address. And unfortunately, that letter was never responded to, but it was the basis on which we then went ahead and instituted this constitutional challenge. There are 3 respondents, being Minister of Justice, the president himself, and also the department or the Minister of Women, Youth and Persons with Disabilities. Now, the president and the Minister of Women didn't respond to our constitutional challenge, but the Minister of Justice did, and he is currently opposing, or now she is currently opposing our application.
But what was the justification of the continued use of the subjective test, at least in those papers?
So according to the Minister of Justice, anything moving away from the current subjective test, which we genuinely believe continues to perpetuate rape myths and harmful stereotypes. The minister is saying that if we are to move on to an objective test, we would be infringing upon an accused person's fair trial rights. Because in effect, what we would be asking for is to shift the burden of proof onto the accused person, who now would have to prove that he took all reasonable steps to ascertain that consent was given. And the minister, for some reason, finds that to be an unreasonable and unjustifiable infringement of the accused's rights. And he also, or she also now believes that we would be lowering the standard of proof in a criminal case, which is beyond a reasonable doubt, and we would be lowering that to a test of reasonableness.
Now, we understand that this challenge has been joined by several amicus curiae or friends of the court. Who are these?
So there are two amici that have joined our application, and that would be the Centre for Human Rights as well as the Psychological Society for South Africa. Their papers actually support the relief that we seek. They have put forward expert evidence to explain what is actually a normal reaction for victims of sexual abuse in the moment that they're being assaulted. They set out 5 various responses that victims could have, most of which is actually a response to freeze. It is very uncommon. Actually, they say that 70% of the victims that they had surveyed would often freeze in a moment while being assaulted. And that it is highly uncommon for victims to actually react and try and push away a perpetrator, or to say anything in terms of like objecting, saying no, don't, or stop. So that is the amici. We also have an intervening applicant in the form of CALS. They've applied to intervene as an applicant in our application. They agree with us as the Embrace Project and the second applicant, who is a rape survivor, that the law needs to change, that there is obviously a big issue around the subjective test, but the relief that they are seeking is very different to ours. And that's why they've applied to intervene separately. They're asking for a relief which would actually remove consent as an element at all in terms of proving rape or other sexual offences. They want to remove that burden from the state and actually require that the accused person brings it up as a defence. And just given the arguments in court today, because today was the first day of hearing this matter, it's finally being argued 2 years after we instituted proceedings. The judge did have a bit of difficulty swallowing, I guess, the relief that CALS was seeking, and actually tried to encourage CALS to align themselves more with the relief that we were seeking.
Leanne, this is most certainly a very important challenge that you've put up now in the courts, and we'll most certainly keep an eye on it to see developments thereof. Thank you very much for your time this evening. That's founder and director of the Embrace Project, Leanne Germanos, talking to us about the Constitutional Court challenge on the definition of rape and consent that they're challenging.